Okay, so this is a special session devoted only to H-1B doing business in the United States. What are the parameters? What do we know? What do we not know? Today, March 8th, 2021, the degree of clarity on this issue is still less than desirable. The bottom line is H-1B visa holders may be able to do business under their own names in their own in through corporations that they own or partly own, but subject to some very strict requirements and also subject to full disclosure to the government that you are stockholder or majority or minority stockholder. So I have with me on the phone a member of our community who had raised this issue about H-1B employees doing business for themselves, and I invited him to join us in a call so that he can have questions as well as input, comments, etc. as we discuss this issue. Sir, you can hear me okay? You know this call is being recorded?
Yes, I can hear you. I'm aware the call is
Okay,
being recorded.
good. And we'll make it available to the community so you can keep your identity confidential. Now, before we begin, do you have any questions? You saw the graphic I sent you. Do you have any questions before we begin?
So I saw the graphic. It basically talks about if you're on an H-1 visa, can you do a
Right,
business?
I'm going to go into the
Or
particulars.
what are your-
I'm going to describe the details. Do you have any preliminary questions before we get started? That was my question.
Yeah, my first question was that if you're on F1 visa and you're trying to get into a H1 visa,
Mhm.
then
Okay, the criteria are the same.
would anything else
The criteria are the same.
yeah, is
So,
it the same or
yeah, the criteria are the same. It has a little added module of information that we can also cover, but the basic idea is still the same. Can an H-1B visa holder do business, okay, through a company or LLC that they own? And first of all, I'm going to just begin the discussion and you can stop me anytime something is not clear. At the end of the discussion, I will cover the F1 to H1 special issue if there is one, but I'll point out to you what you have to watch out for. Okay. So first of all, there are two kinds of, let me just make sure the call is being recorded. Indeed it is. Okay. Just making sure. So there are two kinds of investments or business modalities, active or passive. I am not an expert in tax laws, but I understand that IRS has a definition. Remember, the IRS definitions may not be the same ones as USCIS regards, but they do have some persuasive value. The USCIS opinion about passive and active should be, and there is no clarity on this, it should be where you are not actually doing any work. So what does work mean? It's not a term of art. Basically, it means you are doing nothing. For example, if you invest money in the stock of IBM, it's almost certainly a passive investment unless you become a day trader. That might be a different definition. So we can assume safely that if you put your money into an investment where you have neither any control on running the business or nor are you involved, it's a safe bet that the government is not going to object. USCI is not going to object on that. Does that make sense, sir? Are you good with that?
perfectly?
Okay, good. So now comes the tricky part, where you are doing business actively, where you actively participate. And the answer to that question, can I do business, is yes, maybe, but you've got to meet the following requirements. First one is you actually must have an employer-employee relationship with your own business. Okay, what does that mean? Now, I reviewed this morning all the case law, and so far, the last time USCIS spoke to this issue was still back in 2009, in which they just discussed these issues that we are still dealing with. The employer-employee relationship means your company, your corporation has the right to control, hire, fire, pay, supervise, etc. you. Now that becomes tricky if you are a majority stockholder. So safety feature number one, if you are a minority stockholder, you have a better chance of making this work. But if you are a majority stockholder, you could have issues of control. Who controls you? Because you are really the owner of the company. Now I'll point this out to people that we've done these types of cases successfully before. They have worked out well, but we have made a few things clear to the government, full disclosure, and I'll get into all those things as we continue discussing. So the first thing is employer-employee relationship, right to control, which is hire, fire, pay, supervise, or otherwise control. That's what the definition is. It's right here. Ideally, your business entity should be some type of a corporation, whether it is an LLC, limited liability corporation, or other corporate form. Why is that important? It's important to understand that a corporation or an LLC is an entity separate from you. So for instance, let's say you have a company called Microsoft Corporation. The owners of the Microsoft Corporation are their stockholders. The company by itself is a separate entity. It is taxed separately. And if it does some kind of a screw up, it is difficult for anybody suing the company to also sue the people who own the company. That's called corporate shield. Basically, it shields you, insulates you from liability. So one important thing about corporate entities is that they can be pierced by the government if there is some kind of fraud, etc. But for our purposes, that's not something we need to discuss. And piercing the corporate veil simply means the government can disregard the corporate entity if it is being used to commit some kind of fraud. Corporate formalities are not being observed. You are commingling your own funds with the corporate funds. So for our purposes, what is important to remember is there's employer-employee relationship. There's some kind of a corporation of which you own stock, preferably minority, maybe majority or all. You've got to process a part-time, full-time, or concurrent H-1B through your own business. Otherwise, you can't work for it. You've got to have an H-1B for that entity. Your job must be in your own field. So if you are a software developer and you start a business owning restaurants, that is not going to work, because what does a software developer have to do with restaurants? It's not a specialty occupation. H-1B is a specialty occupation job. Your business must also pay your wages and comply with all the H-1B requirements. It's a genuine job. That is the overview of what kind of setup could work. But let's drill down a little bit into the most important part, employer-employee relationship. The last H-1B of this sort what we did was we had a clear agreement, and this can be a part of the bylaws, articles of incorporation. Typically, I think it's in the bylaws, but that's the corporate lawyer's headache. All I can tell them is, this is what I need, and the stockholder and the company should be bound by this. What we did was, we had an independent board of directors who reviewed the work of the CEO. Our guy was the CEO, who reviewed the work of the CEO and made sure that they had control over the CEO's job. And it was clear that they could hire, fire, supervise, etc. our CEO. That is very, very important. If on the other hand, you're a minority stockholder, let's say there are 3 stockholders and you own 20%, the other 2 own 40-40, obviously you are the minority stockholder, and we should still have a provision in the bylaws of the corporation, which is an internal governance document, that clearly says that they have the right to supervise you, etc., etc. Okay, so if that were the structure, you could at least go before the government, and this is where it is also important to make full disclosures that, look, I own 20% of the stock of the company, but I'm an employee of the company. or I own 30% or 50% or 55%, but I'm being controlled by the board of directors. I have a genuine employer-employee relationship. Let's put this aside for a moment, and let me also tell you a story from our trenches. Somebody that we are representing in a lawsuit against against a visa non-issuance is in a situation like that. He owns stock in his own company. His lawyers did a good job, as far as I know. They made full disclosures to the government that he owns stock. His H-1B was approved. He's gotten several extensions. But this time when he went to India, he is stuck there for the last 14 months. They just won't issue him an H-1B visa. And finally, when we sued them, we found out that they are sending the case back, or they have sent the case back to the USCIS for revocation. So the point is that even though we think it should work, there's plenty here that is unsettled. All we can do is try to make you as safe as possible, but there is absolutely no guarantee that the government is not going to mess up completely. If you're not traveling, good, you are fine. But if you're traveling, this could become even more complicated. Now, to come back to your issue, if I'm on F1 and I want to go on to H-1B, does anything different need to be done? Well, look at what an H-1B employer is. It's a corporation with a tax ID number. If you have a corporation that's properly set up, they can apply for your H-1B lottery just like any other corporation. And once they've done that, then all the discussion that we've had about employer-employee relationship, corporate structure, etc., comes into play. So the only additional module is for an F1 to H1 conversion is that you consider all these things that we talked about and then apply through the lottery. Sir, the floor is all yours. Ask me any questions you have.
Yes, sir. This was whatever you told me. I'm presuming that it's for a company which is already established and which is fully functional. I am looking for some answers with regard to a company which is in the process of being set up.
That's okay too. So, remember, the reason I interrupt you is because there's not a question here that I haven't heard before. So, first of all, setting up a corporation in this country is fairly easy. I won't comment about it because it's a matter of state law. Every state has its own corporate law. So let's just, for example, assume Virginia or DC, where I'm admitted. If we were to form a corporation in DC or Virginia, basically, again, corporation or limited liability company, etc., we would have to first create the infrastructure, get something called a registered agent, and anybody who's incorporating can be themselves a registered agent, or there are professional registered agents who can do it for you. You will start a corporation. That's the number one part. You'll get your tax ID number. That's the number two part. Actually, in these days, we begin with first getting a internet domain before we even start with and we make sure that that's available and taken by us. So you do that, and then you talk about setting up the business. H-1B does not require you to have tremendous amount of cash flow. It requires you to be able to prove that you actually have a job. So obviously, some amount of either business plans or some amount of cash inflow, influx, outflux would be good. But what is more important is that you should be able to demonstrate that you genuinely have a job. If you just say, well, I might get a project once I start my company, you're not going to get an H-1B on that. That's really an issue. So when you talk about a new corporation, the issue is not so much whether you are already doing business or not. The issue is whether you can prove you have a job for the person for whom you're applying for an H-1B. Indirectly, it comes to the same issue. Because if you don't have a running business, how do you prove you have a job? There could be something else. For example, if you have committed funding. Okay, if you have investors that say, okay, we'll give you X $100,000 or $1 million, let's start the business. I think that's a good way to go. We have done plenty of H-1Bs for startup companies. They work fine. The only thing is, the major issue is, do you have a genuine job? That's what you need to worry about. Does that make things a little clearer?
Yeah, it makes sense, very clear. So then whatever you told is in the process, like there's already a website in place and there is email ID set up, and agents have been hired to create various documents and bylaws. The attorneys are on work.
Good.
All those things are in place.
Good.
My only query was that, let me just clarify that it doesn't matter what's the size and the number of employees working in the corporation.
Right.
Is it correct, sir?
That is correct. The only way it matters tangentially, because if you have already a setup with some employees, it shows that there is a genuine job, but not necessarily. We did many years ago, we did an H-1B for somebody who was just out of school, setting up a company with $1 million funding from their school. The school had an incubator that gave them $1 million to start the work. So that was an easy case to prove. Guy had a PhD in his own discipline. He was very, very good at what he did. One of his professors was, I think, part of his setup. But the point is, he didn't have any employees. He was just starting out. We got the H-1B without any issue.
But do you need any amount of fund to be shown when you're setting up? Because, like in this situation, what I'm referring to, the company is pretty small, and this friend of mine who's a US citizen who's starting this organization, it's an LLC.
Mm-hmm.
He is the guy who's putting in all the money. So, like you said, that you can either be actively involved or passive involvement can happen.
Mm-hmm.
So in my case, I'm not putting in any money. So there's no equity involved from my side. So that was another question which I wanted to ask. That if you're not putting in any money, then there's a term which his attorney has told him, which is generally used here, which is called a general partner in the company, wherein he is the partner in the company, but with no stake in the company in terms of equity.
Okay, I'm not going to comment about the structure and the liability of an LLC because that's unethical. I'm admitted only in our states. But the bottom line here is, generally speaking, within a limited liability corporation, there are several levels of activity anticipated. Is there somebody an actively managing person, or somebody is just a stockholder? So the roles have to be defined. But if the role of somebody like you, let's say, is just to be a stockholder, by the way, corporate stock can be sold for $1 per stock or $1 per 100 stock, or it can have no par value. So that's again a corporate hassle that should be resolved with the corporate lawyers. You can own stock in the company with very little investment, less than $100 investment. Okay, so owning stock is not an issue. What is more important is, how do I get actively involved with the business, which is what we are discussing. And even if you are a small company, you could still be actively involved if they have control over you and you are working in your own area of specialty and you do either a full-time, part-time, or concurrent H-1B through them. Okay?
Right, sir. So, like presently I'm on F1 visa, so next January, by then my PhD would be over. So can this company sponsor me for H1 visa then? By then it will be operational, it will be functional.
They will not be able to, because you're subject to the quota, right? If they want to apply for your H-1B, they should do it now. They should do it this year. And remember, you cannot start working before October anyway. Even if they do it now, they put you through the lottery, you win the lottery, you file the H-1B, you win the H-1B, you won't be able to start before October. And if you need extra time to finish your studies, you can request them to hold off on the H-1B. You can file the H-1B without change of status. There's a way of filing H-1B where you say, okay, give me an H-1B, but don't give me change of status. That way you remain on F1, you can even get your OPT, and you can convert to H-1B either traveling outside the United States to get an H-1B visa stamp, or changing status whenever you are ready from F1 to H-1. You will not be subject to the quota. The advantage is that you are already in the seat, you just haven't activated the seat yet. Okay?
Okay, got you.
Yeah, so it looks to me like this should be possible. I don't see why not. As you're not the majority stockholder, you have a US citizen who's setting it up, and it's not required that they have huge amount of funding as long as they can demo that they've got the job for you. And how do they do that? One part is through a good business plan. Other part is through showing they've taken the office, they've set up the infrastructure, computers, whatever is needed. And I think that should at least give you a fighting chance at getting it. Go ahead, sir.
Yeah, but like you said, why not next January? Why this year? Because I think I'm late this year. Because
no, you're not late this year, but you'll be too late in January. The quota opens in March. Okay. So
yeah, but I'm okay with the timeline. I don't want to.
You're okay. Then you're okay. Yeah, then you're okay. The only thing is, if you apply now and again in next March, you get 2 chances. But you're not that worried about it because you have your OPT, then you have your STEM OPT extension. So that's easy enough. I mean, your career path is quite easy. Why? Because remember, in the first year of OPT, you're very free in your employment as long as it is in your own field. It is 20 hours or more each week, and you get paid something or not. You can even volunteer if you want. So the first year is very easy. STEM OPT extension, they have to pay you according to the local prevailing wages. So the first year is quite easy. So I can understand, yeah, there's no need to do it this year then.
Yeah, that was one thing which I wanted to understand. Secondly, sir, suppose there is a situation where the visa is denied. I'm just taking a hypothetical situation for whatever reason. Then this organization has also one company being set up in India, so which is already there, with whom they are getting into some sort of a understanding and they're signing a memorandum of association. So if that company is, a subsidiary of this company which is US based, and if I move to India, then is it possible to get an L1 at any later date?
The answer is yes, but. And the reason I put a but there is because that's a completely different discussion. Okay? That's a discussion that's gonna. We have about 5 minutes left on this call before I go into my next appointment. Okay. I can talk about that with you because that is also a question asked quite frequently. So we can do a call on that.
No, sir, I think I have a couple of.
Go ahead.
I have a couple of 2-3 questions here with this topic on which we are talking.
Yes.
So I think this L1, I think we can put aside for the moment.
Yes.
Sir, what about the prevailing wage rate from the Department of Labor? Like, say, this company is a startup and if they don't have adequate funds to show, like maybe because.
Okay, let me interrupt you. Let me interrupt you.
Yes.
They're not required to really have the ability to pay as long as they meet their payroll. So in your case, your case specifically is easy because first year of OPT, you have enough time to build the company. Let's say the first year is passed and let's say you don't get STEM OPT, you just go into H-1B. The company is not required to prove that they have a huge payroll. They just have to pay your wages as and when determined. Remember, H-1B can also be for a part-time job. So you could even have a job that on a sliding scale, you could have a job 20 to 40 hours each week. These are specific issues that should be discussed before you file. Just know that the possibility exists if the company is still being built up and you don't have a full-time job, they can do an H-1B for a sliding scale or a less than full-time job for you. Okay?
Okay. Right. These are only some areas. So at the moment, can I help this friend of mine to set up the company without being actively engaged? Is it possible?
I am reluctant to say yes to that because on the one hand, you are working but not getting paid for that time. It should be okay. But I am reluctant to say, I would say avoid that, stay away from it. Why put into question your status?
So at this moment, what should be shown on paper I am to be...
If you are going to be a stockholder, if you're going to be a passive stockholder, you should sit together with the corporate lawyers and the accountants of the company and make sure that the stock gets transferred to you with the right riders. I don't know what the riders attached to the stock are, but you can own stock. Just don't work for the company until you get your H-1B.
My without owning any stock, just a sleeping partner or
If you
partner would take.
if you look, there's no such thing as sleeping partner without stock. You got to have equity ownership of some kind in order to be, again, this is a issue of corporate law, not immigration law. But if you wanted to just take advantage of the company's good graces to get stock in the company, I don't see any reason why not. But if you have to work for the company, if you want to do any kind of work for the company, you must get an H-1B processed or be on your OPT or your STEM OPT. Okay.
Okay. So at this moment, he cannot show me any kind of partnership with him if I don't invest any money. That's okay.
No, that's not what I said. Again, that's a corporate law issue, not immigration law issue. Immigration law only worries about you working for the company. You can own stock. That's like passive ownership, right?
Okay. So if the attorneys in corporate law, they have a provision where I can be shown as in any which way as a partner or without any investment, will that be okay in terms of immigration when I'm applying for my H-1B visa?
If it's passive and you're not doing any work, if you're not doing any work for the company, I'm repeating. Yep, that's fine. I don't see any problem with that. I think that should work. I've got to run to my next call. If you have any follow-up,
thank you very much for your time, sir.
You're welcome. You're welcome. And thanks for letting me record this.
I'll do that, sir.
It'll help a lot of people. Thank you.
Thank you.
Bye-bye.
Thank you very much, sir. I've been following you. Thank you for your time, sir.
My pleasure, sir. Bye-bye.